Good day. My name is Oloruntoba Loveth Bukola, matric number 2203010002. I'm a 300 level law student of Adekunle Ajasin University, an IP student, intellectual property law. The matter on ground for distillation today is the case between Zeb Ejiro and Ann Chioma Njemanzi, which is popularly known as the Domitilla case. In this particular case, Zeb Ejiro, who is the petitioner, created the original Domitilla in 1996. Then he made a sequel in 1999. Then the respondent, Ann Chioma Njemanzi, played the lead character in Domitilla in both movies, both the original and the sequel, and she became strongly associated with the name. Then in 2020, Zeb Ejiro planned a reboot, seeing as the movie succeeded. The past two movies succeeded. Then he planned to make a reboot of this movie, and he planned to name it Domitilla the Reboot. He approached Anne to act as the auntie in the new movie to the original Domitilla. However, she asked for a price that Zeb failed to agree to, and then talks broke down because of this price. Not long, about 2022, Anne went ahead and registered Domitilla and Device as a trademark in Class 41. Class 41 covers entertainment, training, and cultural activities. When tried to continue the movie without her, which is the reboot, she served him a cease and desist letter claiming trademark infringement, that since she has registered Domitilla and Device as her trademark, then Zeb has no right to make a movie with that particular name. Zeb petitioned to the trademark registry, arguing that the name Domitilla has belonged to him since 1996, and that since he is the owner and the original creator, therefore he should have rights to it, and that and has no right to register the name or to become the true proprietor of it. The courts in ruling in this case stated that the court agreed with Zeb and stated that Zeb has original ownership and therefore Anne cannot trademark this name. Now, the issues for determination is, the first one is who the true proprietor of the Domitilla trademark is under Nigerian law. Then we have two other sub-issues, which is whether the first to use or first to file determines proprietorship of a trademark, and also whether the tribunal properly exercised judicial jurisdiction despite procedural irregularities in how the petition was filed. True proprietorship of the trademark, which is the first issue, is what we are going to discuss now. The tribunal emphasized that proprietorship is not determined by mere filing of an application at the trademark registry, but by prior use of the mark in commerce. It can be seen from the facts of the case that Zeb has made use of this mark both in commerce, and it has been widely associated with him because he made both movies, both the sequel and the original movie, and he was the original owner of it. This reasoning is consistent with the Nigerian case law of Ferredo Limited versus Ibeto Industries. Then also, the second one, the tribunal's finding that the respondent acted in bad faith aligns with Section 11 of the trademark, which prohibits the registration of marks likely to deceive or cause confusion or marks filed dishonestly. Judicial authority reinforces this, and that is the case of Nokia Corp versus Interservice Limited. The issue of jurisdiction too. A potential weakness in the ruling lies in the tribunal's handling of procedure. The respondent argued that the petition was not filed as an opposition under Section 20 of the Trademarks Act. However, the tribunal relied on Section 187 sub B and Section 221 sub 1, which empowers the registrar to correct errors and withhold registration if acceptance was made in error. Although the tribunal did not directly resolve the jurisdictional challenge, its reliance on these provisions is defensible. In my own view, the tribunal's ruling is legally sound. I agree with the rule of the tribunal that Anne has no right to the trademark. This is because, uh, to a layman, the mark should actually belong to Zeb, because he created this mark, created the movie, and he wrote everything in relation to that particular mark. Therefore, the mark should belong to him. The legally, now, if you are to look at it legally, there are several sections that I can use to back up the decision of the tribunal. If we look at section 9 sub 1 of the Trademark Act, it provides that a trademark must be capable of distinguishing in quotes the goods or services of one person from those of another. This supports the tribunal's finding that Domitilla was already associated with Zeb's work since 1996 and thus distinguished his film from another. Then, if we are to look at Section 11 of the Trademark Act, Section 11 of the Trademarks Act prohibits the registration of marks that are likely to deceive or cause confusion, or that are contrary to law, morality, or public policy. We can see from the above case that not only is Anne's application deceptive, but she knew that the public already associated Domitilla with the petitioner. She knew that Domitilla was widely known with the petitioner and not us, and she still went ahead to register it. Therefore, her mark, that registration she has made, should be invalid. Section 13 of the Trademarks Act also states that a mark shall not be registered if it is identical with or nearly resembles a mark already in use by another person in respect of the same goods or services. Therefore, this section 13, backs the decision of the tribunal in rejecting Anne's claim, since Zeb had prior use to Domitilla in films. Section 18 sub 1 of the trademarks also provides that any person claiming to be the proprietor of a mark may apply for registration. Proprietor is the keyword here, and since proprietor, according to the act, depends on prior use, the tribunal was correct in finding that Anne was not the true proprietor, because even though she was associated with the name, that association would not have been possible if Zeb, the original owner of the mark, had not made her the actress. Anybody could have been the actress. It might have been another popular actress who would have been used at that time, and that person would have been associated with Domitilla. However, the real creator, which is the person who has had prior use, is the person who should be the true proprietor and not Anne. Section 20 of the Trademarks Act also allows for opposition proceedings where a person can oppose the registration of a mark, even though the petition wasn't filed as a formal opposition. This section shows that the law recognizes challenges to wrongful application. Zeb has the right or has the power to oppose the registration of that particular mark, which he did. Section 43 of the Trademarks Act also provides that registration shall not be deemed to confer a right to the use of a trademark where there has been or where there is an earlier right vested in another person. This is also one of my strongest provision in this argument. It clearly backs the tribunal's position that even if Anne filed first, her rights can be trumped or her rights can be taken over by Zeb because of his earlier use and his ownership. Section 187B of the Trademarks Act, which the tribunal relies on, states that it gives the registrar power to correct any error in connection with a trademark application before or after acceptance. Therefore, even though this woman has accepted, or she has registered a trademark, the tribunal has the right and also the registrar has the power to correct any error made in a trademark application, even after the application has been accepted. Then Section 221 sub 1 of the Trademarks Act empowers the registry to withhold registration where acceptance was made in error. This validates the tribunal's decision to cancel the acceptance issued by Anne. Therefore, it is in my own opinion that the true owner of the trademark is Zeb Ejiro, who is the producer and the original owner, and therefore the trademark Domitilla and device should be taken away from the respondent and should be given to the claimant. Thank you very much.